one, to locate his client and report back at 5 so that we may proceed with these proceedings. Senior Counsel Paul Mwite, you may now inform the House so that we proceed.
Mheshimiwa Speaker, through you, I would like to inform honorable senators that I've been able to contact the doctors at Karen Hospital. There are a number of doctors, a team of doctors, who are looking after the Deputy President. Because of his condition, I was not able to directly talk to him on the advice of his doctors. He said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains. I did not want to inquire beyond that, Mheshimiwa Speaker. But just in order to perhaps save the time of this Honorable House, let me, as I sit down, invite Mr. Speaker and the House to look at Article 145 of the Constitution, sub-Article 6. Mheshimiwa Speaker, sub-Article 6 of Article 145 says, if the special committee reports that the particular, if you go to B, have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. Mheshimiwa Speaker, we are aware that this Honorable Senate made a decision to hear the charges in plenary, so that what we are doing in these proceedings, I would suggest and submit we are proceeding under sub-Article 6B. And under sub-Article 6B, this House, by the Constitution, is obligated to accord the Deputy President an opportunity to be heard, which is why Rule 11 of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, sub-Article 6, which obligates this Honorable Senate to accord the...
Doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President...
Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not. This House began. His Excellency, the Deputy President, again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point in time, His Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice and pleadings that have been filed, in this occasion, because His Excellency, the Deputy President, has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forgo the cross-examination of His Excellency, the Deputy President, and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency, the Deputy President. Mr. Speaker, sir.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, sub-article 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find our assessment of the Deputy President states as follows. The President, and for that matter, it should be read, the Deputy President, shall they have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the Deputy President can elect to be represented either by his advocate or by him appearing in person, or having both the Deputy President and would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any accommodation. You'll be out, and there are a lot of, very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us well, or if he has told us the medical institution where the Deputy President is. But for the Deputy President to fail to bring evidence, credible evidence before the House, that has been admitted, even that evidence that has been admitted to a medical institution, the sickness
of the Deputy President is affecting us more, which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this of where the Deputy President is and what elements is suffering for. I think the more important duty for this Senate is to comply with the Constitution. And we urge you to comply with the Constitution and proceed with the hearing of these impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, honorable senators, we all live in Kenya, and I would like outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there PM, and it was a rush. Was I to fail to come back to this honorable house at 5 p.m. waiting for a medical report when the doctors there are busy attending to their patient, the Deputy President? Medical reports I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning.
Senior Counsel Paul Mwite, there is a hypothetical question that was raised by Senior Counsel Orengo. Assuming, and it's just an assumption, assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this Honorable House, Honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable to be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of the Senate, where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly also, through its legal counsel, has also told the Senate that it is
already made on the matter for fating the cross-examination. And Dr. Eric Komolo, that puts or challenges the 10-day timeline that we've been informed about.
Definitely. This is something we totally didn't anticipate.
All right, Dr. Eric Komolo, what do you make of that? It challenges the 10-day timeline.
Certainly, this is something we didn't anticipate. The only good thing here is that it's testing our constitution to the limits we didn't envisage. The fact is that Article 145 4B obligates the Senate, where there's a special...
That's the first option. The second option is to grant the wish of the defense team led by Paul Mwite, the senior counsel, and give the members leading the defense team for the deputy their evidence before the senators when the DP, whom they say is ill, gets an opportunity to come back here, the Senate, to make his case. And of course, it is going to be a legal battle as well because of those timelines that the Constitution, according to some lawyers, are saying that the timelines, the 10-day period, a hearing in terms of what this matter is supposed to undertake, is supposed. It's not taking advantage of this, but Orengo has said this is quite some sort of an opportunistic situation, but it is just the situation that every side is trying to make a case for themselves. But we wait to have that decision in just a few minutes, Olive.
All right, thank you for that update, Cho. So the Speaker, if you're just joining us, the Speaker of the Senate, Amason Kingi, says he will be back in a few minutes to rule on whether the impeachment process on the Deputy President will proceed or if he will grant the application by his lead counsel, Paul Mwite, to adjourn the proceedings until Tuesday. So the deadline, as we calculated, would have been Saturday midnight on the 10 days. Have we been reading these provisions all wrong? Because Mwite has cited Article 146 of the Constitution, more specifically Section 6B, if I got him correctly.
Yes, 64B.
64B.
146 4B.
146 4B. And it states that...
sorry, 145.
145
yes.
4B. Let me see. The 3B shall A, investigate the matter, and B, report to the Senate within 3 days whether it finds the particulars of the allegations against the President to have been substantiated. Then in Section 5, it reads, the President shall have the right to appear and be represented before the special committee during its investigations. Now on to the 6A and B, the B specifically he made reference to. If the special committee reports that the particulars of any allegation against the President have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. So is the 10 days limited to a report to the Senate on the charges?
You know, it will seem that most of us have been taking it to mean that law is normally very fluid. What is their main argument, which seems to hold water, is that what is time-bound is reporting on the findings, not voting on the findings. Voting then is the impeachment process. So if you go by their argument, then it makes a lot of sense to give the Deputy President additional time to, assuming they find it, any of those allegations, they find very reasonable submissions in terms of this need for predictability, certainty in processes that are important to the nation, like impeachment, and therefore the framers of the Constitution, and of course the Kenyan people who voted for him, for it, had reason to put specific timelines for processing a motion for impeachment. So I hope he doesn't take it as Senate Speaker, as I have said now repeatedly here. It needs to go to the senators to debate and take a common stand as a jury. Whatever it is, they must balance all interest and, importantly, leave this process such that it is not subjected to a lot of legal challenges, particularly where
it sits in for the special committee, because 45(5), it says the president shall have the right to appear and be represented before the special committee during its investigations, and it is meant to report back in 10 days. So ideally, these investigations should conclude within 10 days.
If you read it again, shall have the right, in this appear and be represented, not appear or be represented.
Okay.
In other words, those two are conjoined. Shall, not may. After according the president, or the deputy in this case, an opportunity to be heard, according, opportunity to be heard, vote on. And that one, from where I stand, has not happened. And that one is not time-bound. And that's, I think, the loophole there that his team is trying to use here, so that the Senate can convene, say, on Tuesday. The bigger challenge here, if you look at now the mischief, is that you don't know when he will be well. You know, we do not have any meaningful reports other than what the senior counsel said from the bar, that he has chest complications. So there's no guarantee that this will happen on Tuesday. It can happen after a week, after 2 weeks. You may want to say the cat has bolted, so the horse has bolted, sorry, so they will have to just deal with the situation as it is now, which is to have to enforce 145(6)(b) or 6A, because they have not told us, as we speak, that any of the ground is
must adjourn regardless of what the standing orders provide. Impeachment in absentia is a nullity, especially in the case of medical emergency. What do you make of his submission?
I think I significantly associate with Steve, who is my good friend, substantiated, and then proceeding to vote on the impeachment and then impeaching when, as we speak, I'm also receiving several calls. As we speak, everyone seems to be glued, looking at, trying to speculate what next. It won't look nice. It won't look fair. And I think wisdom has to be exercised here to, at the very least, give him a day or so, so that more facts are established, and then we get a clear timetable on how to process this, or whether he elects not to come. But he had, and this one, it doesn't seem to speak to him being heard through counsel.
Okay. The provision that the Orengo team has relied on, the National Assembly legal team has relied on, are the
works in a society that has rules, that also has situations, that has context, including political situations. And so the Senate can, and that's why the Speaker, I think one of the standing orders also provides the Speaker to exercise discretion on a number of things. So it is not kind of any of the grounds substantiated, or whether they think that the evidence killed the evidence that was presented by Honorable Mututse. I don't know. What I know for sure is that due process and the procedure enshrined under Article 145 envisages that the Deputy President be heard, and substantively so.
Okay. Yes. Another advocate, Charles, this should be weighed against evidence of the alleged illness, which he says is lacking.
Charles is also a good friend of mine, so that just confirms what I've been saying here, that there's no consensus. And the three of us, whether he went through by ambulance or drove himself, or was driven by his regular driver, there seems to be no contest that he's in hospital. You see, so
Is there not? Because Orengo has said, ideally, I mean, he says for it. And I can't remember who it is who was arguing that maybe one of the doctors should have availed themselves, and because even a letter could have been a forgery.
Yes, but if you listen keenly, the governor himself, Governor Orengo himself, then gave a rider that condition will have to leave to competent medical doctors. The bigger point...
So what happens in a post? What is the standard of proof?
Courts generally tend to be lenient in terms of giving parties opportunity to appear until it looks like they're abusing the court process. So the regular judicial process will be that if a party is unable to appear for a reasonable cause, then there will be given time, the court will adjourn. But this is not a court of law. This is a Senate sitting as a jury in a rather politicized environment. But they're also bound by rules of natural justice. And that is why I'm not talking about Tuesday. That's why, to my mind, I think it's probably beyond us as we speak. The bigger point is that since we are agreed that the 10 days are more or less ending on Saturday, then a reasonable process would perhaps give the defendant here, the deputy president, opportunity or esteem for that.
The deputy president reportedly having been taken ill and admitted to hospital after suffering intense chest pains. Let's listen in.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by. I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. On resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes, where the National Assembly or the Deputy President chooses not to appear before the Senate. That fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before. It is also noteworthy that Rule 12 provides as follows. Subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted and be presented in of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Counsel then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Counsel argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forgo the cross-examination of the Deputy President and requested that both parties be allowed to highlight the submissions during the closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) in the manner provided for under Rule 12. In such event, the hearing will continue as set out in the program, with the parties moving to make their closing statements. Honorable Senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere Deputy President of the Republic of Kenya. Next order, clerk. Now, honorable senators, you have been circulated with the supplementary order paper. That is the order paper that we are going to use from now going forward. We'll be called upon to move. Clerk, call the order, please. Honorable senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2020, with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 1, Senate documents in evidence of the proceedings of the National Assembly. And whereas vide Kenya Gazette number 137/18, volume 53A of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution, and time possible without violation of the Constitution, within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from, I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, sorry, my apologies.
Order, 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 honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. it does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana, na macho yote sisi tukasema ya kwamba mtu hawezi kuwa mgonjwa, mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole, Senate imempatia pole, na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment. TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of as sittings convened for the purpose of hearing the proposed move President of the Republic of Kenya in plenary. Further, whereas pursuant to Article 145 as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal of Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office Wednesday the 16th of October 2024 and Thursday 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President, with Article 151(b) and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders. The Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, and Standing Order 78 and 79. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to... Yes, Senior Counsel Paul Mwite.
Mheshimiwa Spika, Through you, let me recognize the right of this Honorable Senate
Now, honorable senators, we shall move to hear the closing statements. You may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you, and much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even the other processes come in, like the investigative agencies. Number 2, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this House is inquisitorial under Article 145 all the way to 149. And therefore it allows this House to go beyond what the mover has brought or beyond what the other witnesses have brought. And this House has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest only legal in process, but political in content.
Time is ripe.
What is the condition of the Deputy President as of now? And you also failed to provide medical reports. Why is so?
The matters of the health of the Deputy President are the matters of the health of the Deputy President are matters of the state. The only person who can inform the state on the status of the health of the Deputy President is the head of state. We lawyers, our instructions are limited to representing him in the Senate.
Under one taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment to the millions that it represents. In the National Assembly, 82% translate to about...
Not only them, or selfishly, but also the country and the family. So I think it's unfortunate that the majority voted against the motion which was put before them. I hope that at the end of the day we'll consider the importance of this country.
What would you describe as happening now?
Well, of course you heard what the Speaker said. They are proceeding, right? And I hope that we'll consider generally the great nation of Kenya, the people of Kenya, and let's see how things unfold.
Wakili Swanya, at the National Assembly, you had an issue with the presiding, citing the Speaker being biased. How would you rate the presiding of the session at the Senate?
And just to add on that, do you think that Gachagua has...
Justification, and I had the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is
You're with your friend and you give the stories the next day in the morning. I was with him, he was laughing, and then he's no more. But we are saying the doctors are taking care of him, and he was willing, even if he was to come here in his hospital bed, he is willing to testify. So it is very sad to see that the Senate is in a rush to determine the case without listening to the Deputy President. So what we are saying is that Kenya has, we have seen how the process has been. We have seen how the Deputy President has been treated. Of course, being treated with allegations that are not able to be substantiated. Kenyans have seen. So it's up now to the Senate to listen.
By positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was not only was he convicted, but even to come here and allege that he was convicted and thereafter, you know, they entered some sort of negotiation is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the Deputy President was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty this motion. He would not actually work with the cabinet, any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the Deputy President today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and they are...
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa muongoje 20 utafute mali yetu na tuna watoto wetu, kisha akifa ende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa Naibu wa Rais wametoshea kupewa urithi wao, Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga, mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka stesheni ya mwisho, kisha akifika kule atajua atatafuta makanga.
Our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the facts to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene.